Good morning. My name is Gail Prudenti, and I am the proud Dean of the Maurice A. Dean School of Law at Hofstra University. On behalf of our visionary president, Stuart Rabinowitz, welcome to Hofstra. The president would have been with us this morning. Unfortunately, he does have a memorial service that he has to attend. But this past week, I must tell you, I have named, I've given it a name because it has been such a special week here at Hofstra Law, and I've named it Judiciary Week, and it has truly been memorable. On Monday, Hofstra Law had the pleasure of hosting both United States Supreme Court Justice Sonia Sotomayor, as well as hosting one of the busiest appellate courts in the country, the Appellate Division, 2nd Judicial Department, which many of you know has a very special place in my heart. It is now my honor to begin the final event of this historic week by welcoming United States Supreme Court Justice Stephen G. Breyer. I would also like to say a special thanks and the warmest welcome to distinguished members of the Judiciary, past and present, and commissioners, leading scholars, and guests of the Hofstra Law Symposium on the original sentencing guidelines. In 1988, Justice Breyer delivered our annual Howard and Iris Kaplan Memorial Lecture. His topic, the federal sentencing guidelines and the key compromises upon which they rest. His speech was published in volume 17 of the Hofstra Law Review, placing the law school at the forefront of sentencing scholarship. The important piece of sentencing history brings us back here today to commemorate the original United States Sentencing Commission and mark the 30th anniversary of the sentencing guidelines. As Dean of the law school, and I am sure many deans would feel exactly the same way, these are the type of events that we truly enjoy, where we can bring together thought leaders, professors, and students to create scholarship that has a lasting impact in an important area of the law. I want to commend each and every one of our students and their advisor from the Hofstra Law Review for this fabulous work in organizing this event. Hofstra Law is proud to be part of the history of sentencing guidelines. I especially want to thank Brent Newton, who was instrumental in making this event possible, as well as his co-author, David Sadu. Since May of 2009, Brent Newton has been the Deputy Staff Director at the United States Sentencing Commission. After graduating from Columbia University School of Law in 1992, he clerked for Judge Carolyn King of the United States Court of Appeals for the Fifth Circuit, and thereafter worked as a public defender in the state and federal court systems in both Texas and Florida until he came to the commission. In 2008, he argued a case before the Supreme Court of the United States. He serves as an adjunct professor of law at both American and Georgetown universities, and also as an adjunct professor of political science at the University of Maryland, Baltimore campus. Quite a busy lawyer and gentleman. He has published 3 books and several journal articles and many book chapters. He was elected as a member of the American Institute in 2010. It is my pleasure to introduce to you Brent Newton.
So I'm going to give an introduction to kind of lay the groundwork for the two panels, and then we're going to jump into the first panel, and I'm going to move kind of quickly because we're under time constraints. So November 1st of this year marks the 30th anniversary of the effective date of the original United States Sentencing Guidelines Manual. So during these past 3 decades, a lot has happened. Over 1.7 million defendants, 1.7 million defendants have been sentenced under the guidelines. There have been at least, and this is a conservative number, 100,000 appeals to the circuit courts, federal circuit courts. Literally tens of thousands of people, federal judges, probation officers, prosecutors, defense lawyers, have been active users of the Guidelines Manual during these past 30 years. I think it's safe to say the guidelines are the primary, if not the defining feature of the federal criminal justice system in the last 30 years. There have been about 24 Supreme Court decisions that in some way have talked about the guidelines. There have been more than 800 amendments to the Guidelines Manual since 1987. So before we get into what happened with the guidelines, it's critically important to understand the world before the guidelines, before the Sentencing Reform Act of 1984, the SRA. So before the guidelines, it was indeterminate sentencing. What that meant was there were no guidelines, there was no transparency in sentencing. There were broad statutory ranges. A judge could sentence anywhere within a range without giving any kind of explanation. And more importantly, there was a crazy quilt of federal statutes, penal statutes. The original guidelines or the original commission tried to locate them all, had a hard time doing them. About 3,000 to 4,000 at the time, probably 4,000 to 5,000 today. And they were all throughout the United States Code. There is no federal criminal code. They were spread throughout. There was uncertainty about the sentence that was imposed. Parole existed at the time. It typically was granted after about 1/3 of the sentence imposed for most offenders. You also had, independent of parole, good time credit, up to 50% for some offenders. And sentencing judges often had this in mind when they imposed sentences. So they would try to anticipate what's the parole commission likely going to do. And they often were wrong. So you would have either unduly severe or unduly lenient sentences imposed in terms of the judge's intent. And finally, there was no meaningful appellate review. If a judge sentenced within the range, that was pretty much it. If a judge were to say something blatantly unconstitutional in sentencing, that might get it reversed. But there were only a handful of sentencing appeals in federal sentences in the pre-SRA era. Then comes the Sentencing Reform Act of 1984, and that's Senators Kennedy and Strom Thurmond, the two senators who were the architects of this legislation. It abolished parole, and it limited good time credit to 15%. It created the Sentencing Commission, had to have at least 3 federal judges, had to be bipartisan. No more than 4 of the 7 members, voting members, could be from the same party. They had 2 main functions, creating guidelines, but then doing research. If you go to the Commission's website, you're going to see a lot about guidelines, but a lot about research, and a lot about publications, and reports to Congress, and so forth. The Sentencing Reform Act created meaningful appellate review of sentences, which is why we've had the 100,000 plus appeals. What the Sentencing Reform Act did not do was engage in meaningful code reform. It did not fix the problems with the haphazard criminal code. That was one of the reasons the commission was created. It was to try to help rationalize the penal code through what were then mandatory guidelines. So there were a bunch of directives in the Sentencing Reform Act. It told the commission, you've got to create this mandatory guideline system with limited departures. That is, most sentences need to fall within the applicable range. You needed to account for the purposes of punishment, retribution, deterrence, incapacitation, rehabilitation. You need to, and this was twice, this was 2 times in the SRA, and it also was in a separate provision aimed at judges, so really 3 times. Avoid unwarranted sentencing disparities and create certainty in sentencing by assuring offenders who commit similar offenses and have similar criminal records receive similar punishments. And the original commission took that to heart. The next thing is from the Senate report, but that's a piece of legislative history that was central to the original commission. It told the commission to create a, quote, detailed set of sentencing guidelines that reflect every important factor relevant to sentencing. One of the critical parts of the original SRA was something called the 25% rule. I call it the 25% 6 months rule. What it says is no sentencing range can be more than 25% from top to bottom, or 6 months, whichever is greater. And finally, the SRA told the Commission to limit consideration of certain offender characteristics, outright prohibited consideration of certain characteristics, including race and socioeconomic status. This was the original Commission. The top, Judge McKinnon from left. Judge McKinnon, a D.C. Circuit judge. You recognize the second person over. He looks exactly the same. Then a member of the United States Court of Appeals for the First Circuit, who had, Justice Breyer had also been a very important person on the Hill working for Senator Kennedy during the time the SRA was making its way through Congress. Professor Block, the third person over, he was an economist from the University of Arizona, an economist who I think Justice Breyer referred to him as thinking sentencing like a blunderbuss, not a rifle. In other words, the simpler the better. And then the younger gentleman, who I should note, everybody here was under 50 except for Judge McKinnon. Everybody here was under 50 at the time. Paul Robinson, a professor of law at Rutgers, he was the sole dissenter who dissented from the original guidelines manual being promulgated. He was a professor of law, a prolific writer. He's written dozens of books, hundreds of articles since then. Sitting down, Eileen Nagel, she was a professor of law at Indiana University. She wasn't a lawyer, she was a sociologist. And she brought the insights of a sociologist, of a social scientist, an empiricist to the Commission. In the middle seated, Judge Wilkins. At the time he was appointed, he was a district judge in the District of South Carolina. He was elevated to the Fourth Circuit while he was on the Commission. And then finally, Commissioner Carruthers, seated to the right. She was a parole commissioner. She had been a warden of a prison in Arkansas, then a parole commissioner on the United States Parole Commission, and she was also a member of the Commission. So you had an interesting group. You had practitioners or former practitioners, judges, social scientists, economists, a person with specialty in criminology. It was a pretty broad and deep skill set that was possessed. So what happened for those first 18 months? And I say first 18 months. The commissioners were not appointed until October of '85, and they were confirmed quickly by Congress, by the Senate, and they had until April 13th, 1987 to produce the original guidelines manual. They met for the first time October 25th, 1985, and they had to get a manual to Congress by April 13th, 1987. That's an 18-month period. They had over 40 public meetings. I've been able to track down minutes from 40, but they make reference to others, so there were many more, I think, probably 50. They had 13 public hearings with over 200 witnesses, a veritable who's who of federal sentencing. Judge Newman was twice a witness. They formed advisory groups, judges, probation officers, practitioners, social scientists, law professors. They heard from all different groups of people. They did surveys of stakeholders. Mr. Martin was involved in that, sending out surveys to people such as editors of newspapers, people who wrote about crime, things like that. Great deal of public comment and informal input from all these different stakeholders. And we'll hear a little bit about this, I think. They did a complex past practice data analysis. They went through 10,500 cases from fiscal year 1985 using what was then an early version of a personal computer, using statistical software, pretty advanced for the time. And then they had 3 different discussion drafts of guidelines that were sent for public comment, 2 of them in the Federal Register. All that in 18 months, plus they produced a thick manual. So what were these policy decisions that they had to decide? They obviously had to operationalize the purposes of punishment, or try to. That was a tough one. They had to do everything they could to avoid unwarranted sentencing disparities, both demographic as well as just inter-judge disparity. They had to decide, do you have a system based on the charge or a system based on what the defendant did, real offense conduct? They had to come up with an approach to that. They had to account for offender characteristics and offense characteristics, and in particular criminal history. They had to set penalty levels in some rational way. That's where the data analysis came into play. They had to deal with alternatives to incarceration. Congress clearly wanted that number to go down. They had to limit departures. And then finally, they had to do a sentencing table. That's where the rubber meets the road. They had to come up with a biaxial grid. So this little pyramid kind of sums up the policy decisions of the original commission. At the very bottom of it, they had to decide what conduct was relevant and what fact-finding procedures mattered, and that's in chapters 1 and chapter 6. The next thing up on the pyramid, they had to come up with an offense taxonomy and set penalty levels. That's in chapter 2 and chapter 3. They had to account for criminal history, that's in Chapter 4. They had to do a sentencing table, that's in Chapter 5. They had to deal with the number and width of ranges and come up with these zones that determine what alternatives were available or not. And then finally, they had to deal with departures, in which they limited offender characteristics for the reason primarily to avoid unwarranted sentencing disparities and not allow socioeconomic factors to be considered. And that finally led, obviously, to what the sentence would be. So before we get to this first panel, I want to talk about the original commission, what I say in proper context. And this is really, I think, is more relevant to the second panel. 1985 and 86, when they were doing the bulk of their work, we were at the highest crime rate in American history, and it was only going up. It went up and peaked in 1991. As far as they knew, it was only getting worse. Many unforeseeable things happened thereafter. Crime rate went down some, but other things happened as well that affected the subsequent commission and the subsequent manuals. Many directives from Congress, dozens of directives from Congress, as well as many new penal statutes, including a lot of mandatory minimum penalties. The commission had to deal with these things. There was no meaningful code reform that ever happened in those 30 years. In fact, it got worse in terms of the number of things spread out throughout the code. There were also significant changes in the federal caseload. Many more immigration and firearms cases than existed in the pre-SRA era. Fewer economic offenses and fewer misdemeanors that were brought. I think it's a really notable statistic. It's in the article. In the year before the guidelines went into effect, 12.3% of all federal cases were DUI or traffic offenses. These were sentenced by the district judges. That drops down to 1% today. So we see a very different caseload. Bigger drug trafficking cases, bigger fraud cases, drug trafficking's in the multiple kilos, fraud cases in the billions, millions of dollars. And the Department of Justice's charging policies. They took a very strict approach. The most serious offense must be charged ordinarily in every case. That kicks in after the guidelines go into effect. And then finally, one thing I want to note is when the commission wrote those guidelines in the mid-'80s, the prevailing mantra among social scientists and policymakers about corrections was nothing works. Prison doesn't work, probation doesn't work, parole doesn't work. Well, we know in the ensuing 30 years, that no longer is the mantra. We have evidence-based practices, both in prison and outside, where we are seeing things happening, recidivism rates going down when certain kinds of practices are resulting. So I say all this because when you're looking at the work of the original commission, and this is what this symposium is about, is the original commission, none of that was known or foreseeable. So we're now going to turn to our first panel. I'm going to briefly introduce the panelists and I'll hit the ground. Judge John Newton is a judge on the Second Circuit Court of Appeals since 1979. Before that, he was a federal district court who sentenced and a U.S. attorney who brought charges in the District of Connecticut. He was one of, if not the most influential member of the Judiciary who advised the original commission. He testified before the commission, but he also provided a lot of informal input. John Steer, he was brought to the commission as a member of Senator Thurman's staff. He was the chief of staff for Senator Thurman, who worked on the Sentencing Reform Act. He came on as a deputy general counsel, who became the general counsel, and served in that capacity for many years. He eventually was elevated to a vice chair of the commission. Rusty Burris was brought on what was supposed to be a temporary detail as a probation officer from South Carolina, and that ended up blossoming into a 32-year career at the commission as the principal training advisor. And finally, Paul Martin was brought as a 28-year-old cub reporter in Greenville. You can see the South Carolina influence here, to be the communications director. And did a great job, not just as the communications director, he actually helped edit the original manual. And then he eventually went to law school at night, became a lawyer, and worked his way up to be now the Inspector General of NASA. So this is a group who knows exactly what was going on in the 85 to 87 period, which is why they're here. So I want to start with Judge Newman. I want to ask you about this notion of disparities. A lot of people say, I think legislative history reveals, that the notion of avoiding unwarranted disparities was the most important thing motivating the early commission. And I'd like you, if you could, to address what it was like in federal court in terms of disparities. And I'm talking about judge disparities, racial disparities, ethnic disparities, regional disparities, all that. If you could briefly address that, that would be pretty helpful.
Well, I'll try, but I hope that's not the only thing I'm going to be allowed to answer.
Oh, no, that's not the only thing.
I didn't come here to talk about the disparities in 1972. There certainly were some. The one I was most aware of as a district judge was tax offenses. Half the judges were locking up tax evaders, and half the judges were not. And it seems to me that you should make a decision. I don't mean to say you either lock all up or none of them, but it seems to me that's a policy decision in general. Does tax evasion generally merit incarceration or generally not? Instead of a 50-50 division around the country, which was not reflecting anyone's policy judgment, but only the individual preferences of the then 800 or 1,200 district judges. So that was the classic one. Selective service was another one. We had selective service in those days, those of you old enough to remember. And some judges were giving 5 years, some were giving 2 years, some were giving 6 months, some were giving probation. Those were the classic disparities I recall. If you want me to go to what I want to talk about,
I promise we're going to come back.
later. Good. Okay.
All right. For Mr. Steer, you served as Strom Thurmond's chief of staff when the SRA was coming to fruition. Can you talk about, briefly, about what that process was like on the Hill?
Good morning. I just want to say thank you to Hofstra for bringing me out of retirement for a day so that I can see so many of my good friends and former colleagues be a part of the program. The Sentencing Reform Act. Thoroughly bipartisan and well considered. A really remarkable piece of legislation. I mean, my former boss, Senator Strom Thurmond, and Senator Edward Kennedy did not agree about many things, but they agreed about the need for sentencing reform, and Senator Kennedy introduced the bill based on some thinking that had taken place at Yale University, and took that concept and developed it into legislation, introduced it in successive Congresses, beginning in the mid-70s. It was considered separately and as a part of the effort to reform the federal criminal code. That effort ultimately failed after being tried again and again. When Senator Thurmond became chair of the Judiciary Committee in the early 1980s, after one last unsuccessful attempt at criminal code reform that included the sentencing reform effort failed, he sat down with the Justice Department. They decided on a criminal law strengthening package called the Comprehensive Time Control Act. And that passed the Senate on 2 occasions. Chapter 3 included sentencing reform. Getting it through the House took a little maneuvering. You're familiar with the concept of adding things to continuing appropriations resolutions that happen at the end of the fiscal year to keep the government running. There was a congressman, there was a member of the House Judiciary Committee named Van Lundgren, who came up with a procedure that added the text of the Senate-passed Comprehensive Crime Control Bill, which contained sentencing reform, to a continuing resolution. That brought it before the House so that the members could vote on the substance of it up and down. It passed overwhelmingly. Brought it back to the Senate. There were some things that still needed to be worked out because there was one senator, Senator Mac Mathias of Maryland, who had was the one who had opposed the initial sentencing reform efforts. And there were some accommodations made with him, such as adding an additional judge member to the Sentencing Commission, mandating consideration and keeping an eye on the prison capacity, and a parsimony provision that said that the sentences should not be greater than necessary to meet the purposes of sentencing. So there were some things like that that were done to accommodate Senator Mathias. He backed off his threat of filibuster, and the legislation was sent to Ronald Reagan and signed into law. That brought it to the finish line.
Well, thank you. Paul, you were one of the original staff members, and I'd like you to address briefly what it was like to start a brand new commission, one that didn't have any kind of institutional predecessor, didn't even have, I think, a line item in the budget. Talk about that process.
Sure. It was madness. Sheer and utter madness from the get-go. The challenge of standing up a brand new agency while at the same time developing the first set of sentencing guidelines on this incredibly strict deadline was frankly akin to building an airplane while flying it, and with a really short runway and homemade parts. It was madness. We first met, as Brent correctly points out in his law review article, in empty offices of the Department of Justice. I believe it was the Deputy Attorney General. The decision was made at that time. So the 7 commissioners, Rusty and myself, perhaps 1 or 2 others, sharing 2 desks, 1 phone. Judge Wilkins met with a gentleman from the General Services Administration, the federal government's landlord, and after that 1 conversation, I think the gentleman from GSA thought he had 18 months to find office space for us, when in fact we had 18 months to draft the guidelines. And so after that 1 conversation with the representative from GSA, Judge Wilkins literally and figuratively hit the streets, walking down the streets in Washington, D.C., looking up at buildings for lease signs.
With Paul.
With Paul. I'll give Judge Wilkins the credit. Found an office space 3 blocks from the White House and signed the contract under his personal name. Violated 37 federal statutes. We don't have a guideline for that, thankfully. Again, the madness continued, attempt to hire staff members, a lot of the commissioners, people that they worked with, they came. If you had a sibling who needed work, you brought them to D.C. For instance. So bringing people on board, hiring researchers, but also hiring people just to function as an agency. Make sure that people had furniture. Make sure that the commissioner's travel was done. We got from point A to point B. Again, all against the backdrop of this incredibly short deadline that the commission had. And that I mentioned that nobody liked us. Not the district judges. Thank you, Judge. Not the appellate judges. Not the federal defenders, for sure. Not most defense attorneys. Frankly, not the Department of Justice most of the time. They didn't like us either. Our brethren within the judicial branch, supposed brethren in the judicial branch, the Judicial Conference of the United States, they were not excited. And the Administrative Office of the U.S. Courts and the Federal Judicial Center were not extending the helping hand of friendship to help set up. So it was madness.
Rusty, you were brought as a probation officer on detail, and probation officers played a huge role in the beginning of the guidelines. Can you talk a little bit about that, and in particular, if you could, talk about the past practice study?
Okay, yeah, I'd be happy to, and I'm happy to be here. Thank you folks for including me here. It feels like old home week, so I do appreciate that as well. I was a U.S. probation officer in the District of South Carolina. Judge Wilkins called me into his chambers and said, Rusty, I've been appointed chairman of the Sentencing Commission. He said, we have no staff. He said, I've hired Paul Martin. I said, and I need Paul. And I said, well, that's good. He said, would you like to come on detail to the commission? Because he and all the commission early on realized that U.S. probation officers were going to be very critical in making this work. U.S. probation officers, long before sentencing guidelines, were always the court's sentencing experts. The district attorney just relied upon the U.S. probation officers. Writing the pre-sentence investigation report, telling the judges what was available statutorily in terms of giving the sentence. When the Parole Commission guidelines came along, the Parole Commission guidelines, how to calculate those, and telling the judge what the parole guidelines would call for an individual who went to prison. And then also just what was available in terms of just of the sentence for this person. What resources are available? Do you want to put the person in a halfway house? Well, they live in a place that doesn't have halfway houses, that type of thing. So the courts relied heavily on probation officers to include, in most instances, in most districts with most judges, giving a recommendation as to what the sentence should be. And the probation officer would actually, at least in our district, draft out that language so that the judge would correctly say that, so there would be no issue about the judge having given an appropriately legal sentence. So the commission realized that probation officers now would be involved in the guidelines sentencing guidelines as well. And so that critical thing was going to require buy-in by the U.S. probation officers plus the ability for probation officers to do it. And so the commission had working groups from early on, bringing in U.S. probation officers, various drafts of the guidelines, and even the ones publicly released, and then the ones that were more internal, having probation officers work through that. And so the U.S. probation officers were actually very happy to be engaged in that process because they knew they were going to be having to do these things. And so there were a couple of things about application. One is the commission looking at, say, some factor for the guidelines that probation officers can't obtain that information because there's no need to have, like, how much time did someone serve in a jail sentence if you can't get that information. So that was critical. But then just the mechanics of the application as well. And in terms of having district judges buy into it, the commission knew that if probation officers couldn't do it, the district judges were not going to be happy with the system that U.S. probation officers couldn't do. So probation officers throughout had been involved. And in terms of this data research, the commission, by statute, the first step they were supposed to take in writing guidelines was to make a determination as to what that existing sentencing system back then did in terms of average sentences for different types of offenses. And for those that went to prison, the statute required that the commission make a determination as to what was the average length of sentence, which wasn't as easy as saying, well, this person got a 10-year sentence and this person got a 5-year sentence, let's do an average, because you had parole guidelines, you had early good time releases, that type of thing. So all that had to be factored in to make those determinations. Well, the commission had a database from the administrative office of the U.S. courts from 1982 to 85, 100,000 cases, that they had a lot of information on. The commission went into that database, looked at it, and determined that 11,000 cases would be a good sample from fiscal year 85 to make a determination as to what was going on in federal sentencing, both geographically and in offense type. So the commission needed more robust information, however. The AO's data was not sufficient to make these determinations. So the commission needed to code 11,000 cases. We had almost no staff. How do you do that? So the commission went to the probation division at the administrative office and said, we have a coding instrument. We would like these 11,000 pre-sentence reports, judgments, and other documents, other court documents, gone through to code these cases. The U.S. probation officers around the country who'd written those 11,000 pre-sentence reports did that. And sent in that information to the commission, and not only that information, but also sent in the pre-sentence reports themselves. So the commission had a more robust database and was able, at that point, to determine, what were the average sentences for those that went to prison, using that data along with Bureau of Prisons data and Parole Commission data, but what was the average length within prison. The commission also had the benefit of then going in through regression analysis, deciding, well, what factors seem to be important to judges in terms of what sentence was given and the length of that sentence. So the commission was able to go in and then figure out, well, in a robbery, it seems like the robbery with the gun seemed to have gotten a little more lengthy sentence by this amount more on an average than the one without the gun, those types of considerations. So the commission did that, and that allowed the commission to meet that initial step. And then ultimately, in terms of these various characteristics, allowed the commission to say, well, what characteristics about offenses do we think would be important? Well, the judges have deemed that these are important factors, and the commission relied upon that. And then ultimately, when the commission made the decision to use this, what's referred to as the modified real offense sentencing system, where you apply the guidelines based on the offense of conviction, but then for the guideline for the offense of conviction, there are a number of real offense considerations. Those really form the basis for those real offense considerations in the guidelines.
Great. Judge Newman, here's your chance.
You're back.
A lot of judges were critical of the guidelines and all the different iterations of the drafts, including you. You wrote a letter that I quoted in the article. Can you talk a little bit about why the judges...
Let me go back earlier, though, because I'm really here to atone for my sins. Before the guidelines, there was the statute. And as it was mentioned, the statute was first developed at a seminar at the Yale Law School, working from the premises of Marvin Frankel's pioneering book. Marvin was part of that seminar, I was part of it. We drafted a statute. The Sentencing Reform Act bears a considerable resemblance to that original work. I can tell you that neither Marvin and I, in urging that the Act call for guidelines, never in our wildest imagination imagine what would emerge from the Sentencing Commission. We thought guidelines meant a small set of guidelines. We had in front of us the Parole Guidelines. You may recall them. Those were guidelines used by responsible people to decide how long a person should be in prison before he's released. And they covered the full range of federal prisoners. And they were 3 pages in length. Now, we didn't expect 3 pages, but we didn't expect the original one, which was 267 pages. And since then, it is now, I have trouble holding it up, but it is now 572 pages without counting the appendices or the. So my first problem with it is that the commission made a terrible mistake back then in opting for something so complicated. I don't think it had to be so complicated. I know there are people who disagree with me about that. But I think it could be done simpler, and I point to the states that also have to have guideline systems, and they figured out how to do it simpler. Pennsylvania, Minnesota, Washington, several others. When I go around the world, and I've had many these Western countries talking about sentencing, and they say, well, we surely don't want your federal guidelines, they're terrible. And I say, guidelines don't have to be the federal system. Look at our states, they have done it better. My problem is the federal guidelines have given the principle of guidelines a bad name throughout the world. Now, I'm not interested particularly in worrying so much about what the foreigners think of us. I'm worried about what happens with district judges. The first problem is it's way too detailed. The number of pages shows that. You have all these fine gradations. Look at the loss table. And before I even get to the specifics, I want to make one acknowledgement. I know I'm going to be told, I have been told, but I'll be told again. Congress has hemmed us in. Congress has hemmed us in, and then there's the 25% rule, which hems you in, although it only hems you in if you interpret it the way your staff interprets it, and not the way Catherine Goodwin interprets it. And as to the 25% rule, I urge you to bite the bullet, do it the right way, let a court decide. If a court rules against you, that's fine. I don't think the federal judiciary is going to rule against the simplification of the guidelines. But in any event, I understand Congress has hemmed you in. You say in the premise, in the early part of it, this is an evolutionary process. You say it twice, and the Supreme Court said it once in using that word, evolutionary. These guidelines have never evolved. There have simply been hundreds of amendments, the most detailed imaginable. Some you had to do, there were new statutes, I understand that. Many were just refinements. There has never been an evolutionary, new look at it to see if you could evolve, go back and test your first premises. What were your first premises? One was that every increment of wrongdoing had to have an increment of punishment. I think that was ill-advised. Your loss table shows that. If you steal $6,500, you get punished more than if you steal $4,500. No penology system in the world makes those distinctions. How does it work in practice? If you go to your loss table and a fellow steals $30,000, you add 4 levels. He steals $50,000, you add 6 levels. Is he more of a villain because he stole 30 more than 50? And what happens to it? At the high levels, that means 4 more years of imprisonment. 4 years, the fellow who stole 50 and the fellow who stole 30. What's the real difference between the fellow who stole 30 and stole 50? It's usually how long the agent decided to investigate the case. He's a postal inspector and was busy. He stopped counting those fraudulent letters and he brought it to the assistant U.S. attorney and looked for authorization. If he had a low caseload in South Dakota, he said, I'll let this run a few more months, and the loss went up to $50,000. Same with tax. The IRS agent says, well, I've got him on 2 years, so I'll bring the case in. Another agent in South Dakota says, I'm not too busy, I'll go 3 years, and then it's a higher tax loss. There is no difference in penality or criminality between those criminals, but they get sentenced differently by a commission chartered to narrow disparity. So I think that's a mistake. I think another key mistake was saying that role of the offense is an adjustment, and amount of dollar loss and amount of drugs is the major determinant of an offense. That has the tail wagging the dog. When I was a district judge, if I saw a criminal who was the head of an organization, he should get a big sentence. And if he or she was a mule, the sentence should be lower. The big determinant of money and drug offenses should be role in the offense. The money or drug should be a slight adjustment. You have it exactly the other way around. You have a big adjustment for money, big adjustment for quantity. Why? Because those are countable. It's easier to count those than it is to count role in the offense. But you could trust district judges to understand that kingpins deserve a lot more than mules. So that part is a mistake. Define distinctions, and I'll wrap this up in a minute. Define distinctions. A judge today has to make a distinction between whether a person's role was minimal or minor. Is that why we went to law school, to decide the difference between minimal and minor? Can't you trust 1,500 district judges to look at him and say, he didn't have much of a role in this offense, I think I'll give him a lower sentence? Or at the aggravating up, is he a leader or a supervisor? That's a wonderful distinction. Is he just a leader or a supervisor? You don't think district judges know enough to know this fellow's a kingpin and he gets a big sentence without having to make a discrete finding, is he a leader or a supervisor? And then incidentally, on some of the injury things, you have a 2-level and a 4-level, and you say, and of course if it's not one or the other, you can go in between and do 3. So now he's got to decide, do I do 2 or 4 or 3? I mean, it's on. In any event, there are many more examples I could give you, but I emphasize, you said it wasn't an evolutionary approach. I think that means going back to your first premises and seeing if you could do better. Now, it's difficult. Congress has hemmed you in, but you're the expert commission. Draft a simplified system. Put it out there. Let us see it. If someone wants to say, commission, we can't do all that. Okay, at least we'll know what you think is the right thing to do. Convene a group of experts. Let them draft it. Let the evolution begin. And if you want to get it done, there are key people, some right in this room, who could pay a courtesy call on the key senators on the Judiciary Committee and seriously talk about the idea of making this workable and less complex. I'm not talking about leniency. With tax, we talk about revenue neutral. I think you can do sentencing reform and have it punishment neutral. I'm not urging severity. That's for another day. I'm just urging simplification to make this thing work. One last thing. One of the things that was done, and I plead guilty to thinking this was a good idea, you eliminate parole for truth in sentencing. That was the phrase, truth in sentencing. Never happened. Why? You did abolish parole, I get that. But every day in the New York papers, which I look at, they talk about a fellow who was released from state prison after 7 years and just held up a person or maybe committed a murder. 98% of sentencing is done by the state courts. All of America thinks there's parole. Why? Because there is. All over America. So what you have done is taken away the opportunity to get, it's not your fault, this is the statute, to be released at the 1/3 point. So judges are now giving 10, 15, 20-year sentences, and the public thinks they're getting out at a third, and they think that because they read that every day when they read about what happened in the state systems. So that was one thing that just didn't work. That's not your fault. Congress did that. I was part of that. I plead guilty.
John, would you like an opportunity to respond to some of the things he said? You were the general counsel at the time.
Well, I think all of those who were on the hot seat, the original commissioners, were very attentive to the statute that they had before them and the well-written Senate Judiciary Committee report. And they tried to be as faithful to those documents as they could. Brent put up the synopsis of the history. They heard from a lot of people. They heard from Judge Newman. They considered all these views. They had some opposing views from the Department of Justice. Like, for example, with respect to the 25% rule. It wasn't just, an opinion that I wrote. It was an opinion letter that came over from the Department of Justice over the signature of now Judge Stephen Trott. And, they took a very strong view that the 25% rule we have something different from what Judge Newman has urged and what my good friend Kathy Goodwin later wrote for the administrative office. That view was reconsidered under Attorney General Janet Reno, and the view came out the same from the Department of Justice. I think they, that all originated with a specific amendment offered by Senator Appellate of South Dakota. And when the Senate was writing this legislation, they didn't specify the terminology. They didn't say that there be specific offense characteristics and that sort of thing. The commission invented those things. The legislation did not even say that there had to be a sentencing table as such. They simply said, and the Appellate amendment nailed it down, that said, commission, however you define an offender with characteristics, that same offender or another offender with those same characteristics appearing for the same or different judge, the sentence should not vary more than 25% or 6 months. And that's what they were focused on. The commission has, I think, relaxed its interpretation of that rule with respect to the consideration of sentencing alternatives. And, I haven't been involved in much of the recent consideration of sentencing alternatives, but I do read the blogs and I try to keep up, and I know the commission has done quite a lot to evolve in recent years and to allow greater consideration of sentencing alternatives, and they're still pushing more in that direction. So there has been a lot of evolution, but there's also, I think, always been a feeling that it had to be faithful to the statute. And anybody that's been on the hot seat, as I have, and as the original commissioners were really only on the hot seat, they're always mindful of what Congress makes. And the liaison with the Congress has been good. I think that that has been true from the outset. They have stayed in close touch. I was involved as general counsel in pushing the commission to make some decisions that later got overturned by Congress. A couple that did get overturned. So I learned the lesson the hard way. Congress is attentive when they are aware of what the Sentencing Commission is doing, and they do care. So I think the statute and the legislative history provide a pretty good roadmap, and the commission has continued to try to follow.
Can I say one word on the 25%, since that's been...
Sure,
Sure, there's a dispute. Somebody in the department said one thing, and somebody in the administrative office wrote an equally persuasive way. I think the other way. As Justice Breyer knows, I always read statutes literally, right? The statute says the top of the range must be no more than 25% of the bottom of the range. Every simplified table I have sent to the commission has the top of the range no more than 25% of the bottom of the range. I follow the statute explicitly. The argument against simplification is that, well, if you give them a little more flexibility with the adjustments, they can outmaneuver the sentencing table. The statute doesn't say anything about outmaneuvering the sentencing table. It says the top has to be no more than 25% of the bottom. All of my simplification proposals comply scrupulously with the statute.
So Rusty and Paul, there were other leading staff members who were not here that I'd like y'all to talk about. Peter Hoffman, David Lombadero, Bill Rhodes. Could you briefly talk about their contributions?
Actually, I was going to talk about a couple of things rather than those folks. They were some brilliant people. I know Peter Hoffman was really the architect of the Parole Guidelines, from which several key concepts were brought over to the federal sentencing guidelines. The debate that we're having, the conversation we're having now, just resonates 30 years later. It's the same conversation, same arguments, goodwill, folks coming to an incredibly difficult issue from different perspectives. I think what's incredibly important to keep in mind is the dynamic that the commission was under, both the political dynamic, and that's capital P or small p, however you want it, both positive and negative, and the intense time crunch, and its incredibly detailed statute that the commission was doggedly trying to be true to. So those were incredible pressures. Along the way, we had some excitement because it was Washington, and we had an ex officio member sitting in for the Attorney General who opposed the guidelines that the commission developed, which was a rather unfortunate outcome for the commission. Thankfully, the Attorney General Meese did not actively pursue up on the Hill Congress stopping the guidelines from going into effect, but that was one of many monkey wrenches that were thrown in. Halfway through the guideline development process, someone came up with a great idea. Hey, we can use the Sentencing Commission as a vehicle to re-implement the federal death penalty. After Furman v. Georgia had nullified the sentencing death penalty statutes across the country, someone, I believe at the Department of Justice, has a wonderful idea. The Sentencing Commission can write the guidelines that will provide proper constitutional protection for capital punishment. And so much ink was spilled and emotions were shed over the discussion, and that was finally put to rest on a 4-3 vote, with the 3 federal judges and Commissioner Carruthers voting against promulgating death penalty guidelines. Because as much wiser and more veteran folks than I at the time in Washington, if our guidelines contained any death penalty language in them, they would have been dead on arrival.
Rusty, you want to talk about some of the other staff members?
Well, Peter Hoffman, who was a long-time drafter at the commission after joining the commission staff. David Lombardero was involved early on. David was a mathematician, well, I say mathematician, attorney, but had a mathematical flair. And when we start talking about these ranges and the 25% rule and that type of thing, and I think I'm correct, and you know from the research, that he's the one that is sort of credited with the structure of the current sentencing table, with the overlapping ranges, meaning the 25% requirement, but having overlapping ranges in that development. Bill Rhodes was our research director, and of course we did a lot of research early on, as I've already mentioned, in terms of what had been happening in sentencing previously and continued with what was happening. In fact, I think, and correct me if I'm wrong, but the commission was the first study, our research department, of when you talk about the disparity, about the demographic disparity. I think we did the first demographic
It's a multiple regression analysis.
study. So those were some of the key players. Of course, I'm sitting folks on the left and right, and in this room who also were involved in that.
All right, well, we've got about 5 minutes left, and I thought I'd give each of you a chance to kind of give a little closing argument if you want to call it that. And in that, I mean, obviously there are positives and there are negatives. 20/20 hindsight's a great thing, but as I tried to point out in the slide, that's a hard thing to do here. So, do you want to make a few closing remarks? John?
Well, been on the outside looking in for a while, and I actually, share some of the concerns that Judge Newman has articulated about the need for simplification. I guess I would go at it a little bit differently. The Sentencing Commission has produced some wonderful, and I think very convincing reports and analytical documents in recent years. And I think they need to produce for Congress a special report that outlines the complications of the guidelines, many of which have resulted from the actions of Congress, directed to the Commission. And sometimes those directives result in the Commission doing a lot of work, but they end up affecting very few offenders. And probably the original Commission definitely would have said, well, handle those things through departure language. Note that this is a concern, and if it occurs, the judge can consider it by going higher than the range or lower than the range, as the case might be. Anyway, I would urge the consideration of a special comprehensive report on the complications of the guidelines and the need for simplification. I don't think just putting it out there and expecting it to rise or fall, and let the courts deal with it as a statutory and constitutional matter is necessarily the right approach. The other thing that I think the commission needs to look at is the mathematical foundation. Rusty mentioned that we had a mathematician or a person with a mathematical background on the staff, David Lombardero. But if you look at the guidelines, the foundation for the aggravating factors, there are several different mathematical slopes, if you will. There is the multiple count rule, which increases sentences if you have multiple counts of unrelated conviction, but it does so at a decreasing rate and eventually tails off. Contrast that with multiple, they're called specific offense characteristics in a given guideline, which increase this sentence at an increasing rate. And if they are too numerous, can actually drive the sentence through the roof, if you will. And then somewhere in the middle, there are the quantity tables, which tend to increase the sentence also, but also have a venture downward slope. The commission, I don't know which of these is, from a criminological standpoint, the right approach. But the commission needs to, I think, to rethink. And then you got the criminal history points and categories that have their own separate slope. So I think, I would urge the commission to give some serious consideration to the mathematical foundations and rethink that as they're going about some simplification.
Judge Newton?
I agree, a report such as has been suggested would be a very useful thing to do. But I don't think you should shy away from having your staff or asking others to take pen in hand and see what simplification would look like. Your chairman made a speech to the ALI urging simplification. But to the lay audience, to the informed audience, even to the congressional audience, the word simplification doesn't do it. And it's going to be misinterpreted as leniency. So if you put out 1, 2, or 3 possible variations of a simplified system, so people know what you're talking about. The public doesn't understand this. Even the sophisticated editorial writers don't understand this, and the congressional people don't understand this. So try it, or if you haven't got the time to do it, because your staff is busy drafting next year's amendments, convene an advisory group and charge them with the task of considering different proposals. You can invite them. I'll spend mine again, I'll be glad to. Put out 2 or 3 as possibilities so people know what it would look like. If it runs up against the 25% thing, then air that dispute. That's not written in stone. It's in the statute, but the statute, as I pointed out, I comply with it literally. And I think that's enough. Others may disagree. But try it out. As you say in your beginning, you have an evolutionary process. Let the evolution begin.
Rusty, what's your big takeaway from the 85-87 period?
Well, my big takeaway is that the commission, first of all, remarkably got the product out. And it was a product, I think, that was actually pretty well received. Probation officers were able to do it, which was critical. And in fact, in doing it, I think that it felt pretty comfortable because the characteristics that they were looking at were the things that they probably didn't consider before the approach the commission took. So they were doing things that they were accustomed to doing, looking at a robbery. Was there a gun involved? How much money was taken? What was the injury? That type of thing. And the judges were pretty comfortable with that. I think the main complaint I heard early on was just the severity of the sentences. Now, I've had coworkers over here say, if we went in and said, cut the drug guideline in half, and the sentences cut them in half, that probably would reduce most of the criticism that we're hearing. Now, as there have been additional amendments to the commission, to the guidelines over the years by the commission and sometimes by Congress, sometimes the guidelines, there's complexity now that I really don't think existed actually in that first round of guidelines. That people cross references in some instances, that type of thing. I think the good news is that the system has been working on the same foundation for all this length of time. We have a lot of people that are accustomed to sentencing in the federal system. So even if you're just going to start looking at simplification, there's sort of a base to work from now that really hadn't existed probably when we wrote the original guidelines.
Paul, same question?
Just that 30 years later, I come to realize that all my life's a circle, and things I will not sing the entire song for you, unless asked. Is that right now, if you read any newspaper, there's criminal justice reform up on the Hill in Washington, bipartisan criminal justice reform. Now, whether it will ever escape the Senate and whether or not it will ever be enacted, but this is an ongoing conversation that we need to continue to have. And it's an important conversation. My wish list, going back 30 years ago, it's politically unrealistic at the time, but my wish would have been that the Commission was able to disentangle the drug quantity guidelines from the mandatory minimums. Mandatory minimums came after passage of the SRA, and I think that the Commission frankly made the only decision it could have by anchoring the drug table based on those mandatory minimums, which I think 30 years later, most folks have come to realize were enormously high. But you know, in my perfect fantasy world, the Commission would have made its own decisions about where to place those, and then when there was a conflict with the statute would have prevailed. But that's not the world we lived in then. Perhaps it's the world we can live in now.
If you join me in thanking the panel.
My name is Jonathan DeMars. I'm the editor-in-chief of Volume 46 of the Hofstra Law Review. Today, I'm undoubtedly one of the most fortunate law students in the nation. Aside from the great honor of being chosen to introduce this afternoon's keynote speaker, I've had the pleasure of working with a number of people without whom this event could not be possible. I've received the unwavering support of Mr. Brent Newton, our author whose dream it was to hold an event just like this, our administration, Judge Gail Prudenti, and Lisa Montecholo, our Dean of Students, all of my outstanding colleagues at the law school. Thank you all very, very much. I would also like to thank each of our esteemed panelists for being here and for offering their perspectives and moving this important area of the law forward. And additionally, to all the members of the judiciary that are here, thank you very much from all of us in the Hofstra community for being here this afternoon. 30 years ago, Justice Breyer delivered the Kaplan Memorial Lecture here at Hofstra, as Judge Prudenti told you earlier, a speech which was published in the Hofstra Law Review. It was a key to our prominence as an emerging law journal. It provided a foundation for understanding how the original sentencing guidelines came to be. In those remarks, then Judge Breyer emphasized compromise between the original commissioners, and that only after reflection could meaningful academic discussion, criticism, and eventual improvement take place. Both with sentencing policy and our discourse more broadly, I think that still rings true today. The Honorable Stephen G. Breyer is a graduate of Stanford, Oxford, and Harvard Law School. He taught law for many years as a professor at Harvard and the Kennedy School of Government. He's worked as a Supreme Court law clerk for Justice Arthur Goldberg, a Justice Department lawyer in the Antitrust Division, an assistant Watergate special prosecutor, and chief counsel of the Senate Judiciary Committee. In 1980, he was appointed to the U.S. Court of Appeals for the First Circuit by President Jimmy Carter, becoming chief judge in 1990. And in 1994, he was appointed Supreme Court Justice by President Bill Clinton. I'm extremely humbled and honored to introduce Justice Stephen G. Breyer, Associate Justice of the United States Supreme Court.
Thank you very much. It's terribly nice for me to be here. I mean, one of the lines in Shakespeare that I like the best is that we saw not too long ago, Henry IV, Part 2. Okay, now in this, there's a scene where Falstaff comes up to the old judge. And the old judge is sitting there with his great friend from law school. And the judge looks back at him and he says, you know, he says, those were the days. That's great. And I see so many friends from that period. It was a little rough, that period. But my goodness, it's nice to see them, Rusty and Paul and John Newman, everybody. It's really great. And I dug out a speech I gave 10 years after I talked here. And I thought maybe I can find some things that'll be relevant. I gave a talk about the guidelines at I think it was at Hofstra. It was in Nebraska at the Hofstra Institute. It was a pretty good institute named after Roman Hofstra, and he was there, and I talked about the guidelines, and I looked through that. My God, everything I said then was relevant, and I think nobody will pay more attention to what I say now than they did then. Which is, there we are. But I remind John but when Ken Feinberger was really working on this nonstop for Kennedy, I mean, we were trying to find things, if I'm really honest about it. We wanted to find criminal justice reform or justice reform things that were totally unopposed. You know, so then we could say, see, our committee's doing its job. And we found a few. And by the way, they've turned out some of them pretty badly, but nonetheless, hardly anybody opposed it. I mean, it was Frankel and Newman and various others. That was a great idea. Okay, so we went through and got this thing written up, and it may not have been written up perfectly, but nothing is. And even then, there wasn't much opposition until the guidelines came out. Then I remember one talk I gave in the 11th Circuit. I had to explain them. And Judge Hill, who was a wonderful judge, I was sitting next to him at dinner, and he was making conversation, and he said, well, what did you do before? Oh, I remember when it was, by the way. It was October, or maybe it was November 1988. Was that when the stock market took a... Yeah, okay. This is a month or so after. I think that was the end of the dot-com boom or something, or it wasn't great. Well, anyway, I was sitting next to him, and he said, well, what did you work on? What did you do before? And I said, well, I worked for Senator Kennedy, and I worked for him twice. He said, well, what did you work on when you were first there? He said, I worked on airline deregulation. Oh, he said, you worked on airline deregulation, did you? I said, yeah, we did. And he says, and now you've been writing these sentencing guidelines, have you? I said, yeah. He says, they didn't just put you in charge of the stock market. He said, so there we are. So I'll simply remind you of a few things that going back to that period. I mean, when I spoke in Nebraska, I made 2 or 3 suggestions, which are probably the same suggestions I would make right now, and they're pretty hard to carry out. And it wasn't just that, John, that there were a few tax discrepancies. I mean, we had a lot of facts and figures that showed that the discrepancies in sentencing by federal judges was pretty bad. I mean, they showed, for example, if you were black and in the South, and you did exactly the same thing in robbing a bank, your sentence on average was 13 months more than if you were white or not in the South. And they showed that they did a test in your circuit, in the Second Circuit. I don't know who did this test. I think it was the FJC, somebody like that. And they had all of these fake cases, you know, and they'd give them to the different judges to sentence. And they got wild discrepancies. I mean, really wild. And that was what Marvin Frankel and others used to say, look, if it doesn't depend on the judge, if it just depends on the crime and the person, why are you assigning judges by a lottery wheel? That's a point. So we did go into this because we wanted 2 things. One was greater. I put ER, not EST. Not perfect fairness, but increased fairness, where people were treated more alike, not perfectly alike, more alike. A little bit eliminating the discrepancy. That's the object. And the other was honesty in sentencing. And I don't know what people think, but it is true that there used to be things where the federal judge would appoint, sentence for 20 years, and then the parole commission would cut it to 7. And then the judge, who was annoyed at that, next time would sentence to 60, so it would only be cut to 20, and that time the parole commission fool him and only cut it to 30. All right, so whatever it was not straightforward in the federal system. So more fairness and more honesty. But the perfect is the enemy of the best. Nobody expected the best. Okay, so that is not. Now, what do we end up at? Well, it's a much harder job writing federal guidelines than you might think. The states we discovered that the state of Seattle, that's not a state yet. The state of Washington, I have it here, I think had Washington state has about 100 separate criminal statutes. The states don't have that many criminal statutes. The feds have 700 at least, and growing and more. Why? Because the states tended to follow the model penal code suggestions, which are, you have a behavior, it's a crime. This behavior is this crime. The feds have not, because a lot of what they do is jurisdictional. So try the Travel Act. Say, what's the behavior that violates the Travel Act? All kinds of behaviors. But there's a federal hook for jurisdiction. Try the Hobbs Act. Try a lot of them. And you will discover there are many more statutes. And in addition, there are many statutes that cover wide ranges of behaviors. Well, we're trying to write for behaviors, not statutes. If we try to write just for statutes, you know, that's easy to do. This statute has this sentence. Oh, fine. You turn all the power over to the prosecutor. I mean, that is a problem. You turn a lot of power over to the prosecutor. And we didn't want to turn power over to the prosecutor. What we wanted to do was to take power from the prosecutor and to have the sentence roughly, very roughly, reflect what was, in fact, the behavior that underlay the crime. And the offender. But we didn't do too much with the offender. Why not? Well, we didn't do too much for the offender because we got into a lot of arguments. Why did we get into a lot of arguments? Because we know one thing, no, you knew nothing for certain, but you know one thing fairly certain, what the past record is. And that did correlate with an increased tendency to commit crime. But what is the next thing that correlates most closely with committing crime? Arrest record. You want to write these guidelines to make the sentence go up with arrests that didn't result in a conviction? Oh, at that point. Okay, and then we tried to look for a few others. We couldn't have a hard time finding them. If there are some now, I mean, they're all over the lot, or they're not. And so we thought we'd stop pretty much with, now that is what happened. Whether it's the perfect thing to have happened or not to have happened, I don't know. But that really is roughly what happened. And then when we went to figuring out what's the length of the sentence, should it be charge offense? No. Well, what about real offense? We did have one commissioner, Robinson, as you recall, who should I tell the truth about this? Well, he was determined. He was going to make every sentence turn on what the real behavior was, to the nth degree. And he came up with something. He really did. But it was, you know, like using calculus and mixed with trigonometry, and I don't know what it was. So Feinberg, I showed it to him, and he and I looked over this, and McKinnon, and we said, no, we can't do this. We can't. We said, no. Arthur Garrity said, no, please stay away from this. The judges we tried it out on say, don't go anywhere near this. It's an impossibility. This is ridiculous. So what we did was we convened for Billy Wilkins, who was, you know, wanted to get something out. We had Billy Wilkins, Ken, me, and we set up a panel. Newman, Ace Tyler, and Frankel. Wasn't Frankel there? Yeah, then the three of them. So we said, well, what do you think of this? Saying this in a rather naive way. They said, what? That was basically enough that we ought to try a different approach. And so we did try a different approach, and the different approach was gradually worked out where we called it the X version, and Lombardero had a lot to do with it, and Hoffman had a lot to do with it, and you all did, and Michael Block and I sat down, and I thought the key moment for my own psychology was when Michael Block pointed out quite clearly to me, I took it in, that God doesn't tell us what the right sentence is. You know? There is nothing that is going to tell us exactly how a person who has done a wrong thing should be punished. And therefore, don't worry too much about being crude. Don't worry too much about using the blunderbuss. Don't worry too much about trying not to get it exactly right. You will not get it exactly right. But just try to reduce the unfairness a little, a bit. And once we began to take that approach, well, what do we start with? We have Bill Rhodes. I forgot Bill Rhodes. Bill Rhodes, of course, had the 10,000 real cases. You know what their crime was. You know what they were convicted of. You know what their past behavior was because it's in the pre-sentence report. And you know what happened to them. You know how long they stayed in that jail. So we had 10,000 of them in the computer, and we could work with the 90,000 others that made 100,000 or so. And therefore, we had pretty good data on, one, what really happened to people over the preceding few years, and moreover, what were the factors that the judges really used. So that was in a big computer printout, and that was over in the corner. And so we had a lot of late night meetings, and they'd go on and on and on. Because the deal was, start with draft X saying what really happened. Now, we can modify that because there will be irrationalities, but let's discuss each as a modification. And so when I didn't like the modification, perhaps, or somebody else didn't, they'd say, well, let's look at what Rhodes says. And then people began to say, okay, the answer's in the corner. We know it's all these crumbled up papers in the corner. And, but that was slightly comical or tried to be humorous, but it wasn't humorous. I mean, it was a serious matter. And we would go look at what they were, and then we'd have to try to debate, should we or should we depart from what the history tells us federal judges have, by and large, actually been doing. And the main thing on drugs, the thing that accounted to the most, the thing that was absolutely high correlation with sentence was amount. I'm not saying all the amounts we have, but that was there, and that's what judges had been doing. Now, okay, then we come along with the later things, but it was true. That's what was there. And so we did finally go around the country, but we had gone around the country with some earlier versions. And so my personal belief is that the total negative reaction was a little bit to those earlier versions, which the later version had taken the comments, which were serious comments, into account. Not perfectly. But you see, we had to start roughly with what the judges had been doing. Start roughly, well, we couldn't use charge offense. We couldn't use real offense. So we had this concept called relevant offense concept, and that had to work crime by crime. So you had to say things, when a person, for example, commits a drug crime, don't count the money that he stole, or something like that, because that's really too far distant from what he's being accused of. That's fairly subjective. But the relevant conduct bit by bit was one of the harder things to work out, and we did work it out eventually. I'm not saying again that it was perfect by any means. It was a set of human beings trying to make a rough approximation of what kinds of things you should or should not take into account in sentencing for this kind of a crime. And that can be very distant. And we also had to remember at that time that the person who was going to be finding the facts was the judge, not the jury. And when the judge finds the facts, of course, if you don't like something and you are a defendant and you think the pre-sentence report is wrong, you have a chance to contest it. You did it that time, before the judge. Well, all right, that's something. But it wasn't the jury. And if you're going to go to the jury, I've said this in opinions, if you're going to require the jury to do all that, i.e., they have to find out, and the first reaction of the defense bar is, the jury should decide what the facts are. And great, so I say, well, that's interesting that you think that, because now suppose what your client says, I was in Chicago and the drug transaction took place in New York. But by the way, it wasn't a kilo, it was only half a kilo. That's what he's going to tell the jury? Oh. Now, they're not being stupid, because their job today is very, very much more not in the court. They're before the prosecutor. And since they're before the prosecutor, they want to use it as a bargaining tool. And they want to say, you don't like my view of this? Okay, let's go to court. And so they're not so upset about the thing that I was upset about. But all that is an interplay. And there were reasons for doing what we did, and some of them hold up fairly well, and probably some of them don't hold up as well as we thought that they would. All right, so what were my suggestions at that time? And they still would remain suggestions. I said, I have some suggestions. Suggestions, one for the Congress, one for the Justice Department, and one for the Commission. And my suggestions, which are imperfect, for the Congress was, I cannot believe this, we never thought it. Can't you stay out of it? I mean, it's like the man, you put in the Sentencing Commission as a sort of preferable version to the Parole Commission. You put it in a way trying to copy what they had in England, which was they had what's called the tariff. And the tariff was sort of a rough idea of the kinds of sentence you'd give for this kind of behavior. But it wasn't written in stone, and it wasn't, that's what we thought it would be. Judge, you have a typical case, apply the guideline. Judge, you have an atypical case, depart. Give your reason. The Court of Appeals will review it, and the Commission will collect what the Courts of Appeals say and what you say, and therefore there will be an iterative process where these guidelines improve over time. And I don't think it's true that they haven't at all. I think that's overstated. I think they do. I mean, they do studies. They do read them, and you do see changes. And I think some of the changes have certainly, I mean, I'm not positive, I'm not an expert on this anymore. You'd have, they would know. I think some of the changes reflect what judges have been telling them. And that's what they're supposed to do. Not all. And I don't know how many. But that iterative process was what was supposed to happen. And then it didn't happen very much. And now it's happening again because of Apprendi and Booker. And the cases that said, oh, well, the Apprendi was not my favorite, but nonetheless, Booker said the guidelines are really voluntary. Use them as advisory. And then they have some jargon. I can't tell you what it was, whether it's a departure within the guideline or a, what's it called? A variance. Whoever made that up was an expert in confusion. It seemed to me that it's the same thing, or it should be about the same thing, really. But there we have two words for roughly the same thing. And so I think, I'm going to vary from the guidelines. I'm not going to apply them. I think to myself when I see that sometimes, hey, why didn't you just depart? I mean, if you read the beginning now, the introduction is the same as it was when we wrote this in 1988. And it says, and this may lead John to that conclusion, it says, we really haven't considered anything with care. And we mean with the care it deserves. Therefore, Judge, you have an unusual case, depart. And the Court of Appeals will look at it. The Court of Appeals should defer a little bit to you insofar as you're talking about the individual. But if you're talking about, can write a better guideline from my bench without any information than the Commission can from its offices with the staff and with much more information, if that's your point, Judge, maybe they should defer a little bit less. But that's another kind of a side issue. All right, so what was my point? Stay out of it, Congress. Okay, they're not going to listen to me. I mean, why? Well, I think when they start passing mandatory minimums, unbelievable. I mean, at first thing it's like a person who's too cold, so he comes into the house, and so he turns up the heat to 78, and then having done that, he sits down and puts on his overcoat, and then he puts on another overcoat and a sweater. Please, you're overdoing this. Don't do both at the same time. And aside from the many other problems with mandatory minimums, that they drove the drug guidelines, and I can sympathize with the Commission's awkward situation given that circumstance. And moreover, they don't give the judge the opportunity to say, look, this guy did transport 40 tons of cocaine across the international border, but it was somebody who was lying on the dock somewhere, and they just dragged him to the cab and says, here's $40, take it across the line. Please. Mandatory minimum, 25 years. Did you see, mandatory minimum takes away flexibility. It's not the guidelines. But the judges didn't know that. Maybe they still don't. And so they blame the guidelines for everything. But love to get rid of these mandatory minimums. They've weakened them in certain parts and they've monkeyed with them and so forth. Now, how can we get rid of them? Oh, and by the way, Congress also thinks it's a fine idea to go and interfere by saying, and put an add-on here, put an add-on there. I have a constituent who really hates fake diet foods, you know, and doesn't think they work. So anybody who is fraud in the diet food business, life. You know, I mean, all right, now you get the point. They don't really do that, but they sometimes come close. Okay, so stay out of that. Stay out of it. Don't do it. Probably your staff person may or may not understand what was just said, which is these guidelines are logarithmic. And that means, I don't know, the logarithmic worked pretty well at the beginning. That means, look, a 10% of 1,000, what is it? 100, I'm not a mathematician. 10% of 10 is 1. They go up by percentages. So if you add 10% when you're already at 1, you're going to get 2. If you're up with 1,000, you're going to add 100 years or 10 years or something. You see the difference? And so if you keep adding on, you keep adding on and adding on and adding on law, well, you're going to end up with sentences that really don't make any sense. Because they're going to make a much higher sentence when the person had done something serious. Now, it may be a bad thing to carry a gun. It is. But is it 100 times worse or 10 times worse if you carry a gun when you're doing a little crime than a big crime? I mean, I don't know why. You see, so when the Congress gets involved in all these add-ons and says, do this add, but look, it's Congress. They're the elected representatives. See, that poses a problem. And somebody just asked me, well, suppose we went and talked to the senators. Please, me talk to the senator? And I'm not saying because the Supreme Court, nothing to do with that. I talk to them, fine, talk to them, they'll be polite. But you don't have what used to be called, in very olden days, I don't even know if this term exists, but there used to be something called political juice. And that meant you actually had an impact. And that's a different matter. That's quite a different matter. So that brings me to the second recommendation. Who has the political impact? The person I think who has the greatest political impact in this area is the Attorney General of the United States. And no one else. And therefore, the second thing is somehow the Department of Justice must get on the commission side. And to get on the commission side, you have to have staff people in the Department of Justice who are willing to spend 4 or 5 or 10 years understanding sentencing and understanding the guidelines. Ron Gaynor, Roger Pauly. They may not have liked what we came up with, but they understood it. They really understood it. And if you bring somebody from the criminal section, the criminal division, and that person's going to stay there in his career for a year, I doubt it will work. Maybe he's a genius, but maybe not. And you have to be has to be 1 or 2 people, and they have a voice on this commission. And that voice has to be exercised in the long-term interest of sentencing guidelines, which means rationality, which means the third point, short. And unless we can get them in there, and I don't know who can, but there has to be a staff voice representing the department who will be backed up by the Attorney General, who will be a voice for not just, it's not shorter versus longer. I mean, maybe it should be a little shorter in some of these areas. I agree with that. But that needn't be the issue. That needn't be the issue. The issue has to be rationality. And the people who can do it have to be the staff of the Justice Department, and the others have to know it too, of course. But the staff of the Justice Department, and that staff has to be backed up by the Attorney General. And the mystery here is, how did the Parole Commission, for so many years, remain so immune from the influence of politics and the guidelines? You see, we had, when we were writing it, we had the that was the model, and it didn't occur, I think, to anybody that the political involvement would be as great as it has been. I just don't remember anyone discussing that. I think it was sort of an assumption that it wouldn't be. It would be more like the Parole Commission, more professional, etc. Well, it hasn't quite turned out that way. And then, of course, I do, as a third thing for the commission, I think to the extent you can do it, simplification is important. And everybody knows that, you know. It's a question of bringing it about. And it's hard to do. Not really hard, I think, technically. And I don't think that necessarily you have to get rid of the 20. It might be nice to be able to get rid of that 25% thing, but I don't know that it's absolutely necessary. After all, the reason, one of the reasons that first edition is as long as it is because there's so many federal crimes. And you have to list each one. And then you have to key them to behavior. Look at any individual, except for the drug table. Look at any individual crime, it's not so long. Until you start getting the add-ons. And then it becomes a mess, I think. I agree with you. But is that a technical job? In part. I think it is in part. I suspect, but I'm not sure, that a commission that is dedicated to simplification by removing every add-on you remove, somebody is going to say, what do I call it as the enemy here? It's called the legal mind. We wouldn't be here if we weren't lawyers. And the first thing you learn in law school is start to make distinctions. Well, that's the problem here. I mean, we make distinctions. Are you telling me that the person who does it this way isn't worse than the person who did it that way? Yeah, he is worse. He is definitely worse. But that doesn't mean you have to write a special add-on. That's hard for a lawyer to accept. Because by the time the lawyer has gone to all the trouble of figuring out that there really is a difference, and it's sort of, you know, wounding not to turn that difference into something. But that's a problem. And I think Bloch was right. Luckily, he was an economist. And he said, don't make so many distinctions. Keep it simple. All right, now, by coincidence, I said roughly the same thing to the Roman Hruska Institute 21 years ago or so, 19 years ago, and nothing happened. But hope springs eternal. And there we are. That is the state of England.
I'm Burke. I'm on the faculty here at the law school, and it's a great honor for me to be able to moderate our afternoon panel. I'm going to make introductions extremely quick because I want to maximize how much time we have for our discussion. The Honorable Judge Charles Breyer is a senior judge on the U.S. District Court for the Northern District of California. He's also a commissioner and former vice chair of the U.S. Sentencing Commission. Judge Hofstra is a judge on the U.S. District Court for the Northern District of California and is a former chair of the U.S. Sentencing Commission. I'm so sorry. Okay, I already messed up. Thank you for correcting me. Went too fast. Judge Patty Caceres is Chief Justice of the U.S. District Court for the District of Massachusetts and also a former chair of the U.S. Sentencing Commission. And Professor Kate Stith is the Lafayette S. Foster Professor of Law at Yale Law School. A former AUSA for the Southern District of New York. She's also a prolific scholar on various issues of criminal law and procedure, but notably for today has been called a sentencing guru by various academic blogs. And I'm going to try to do my best to keep up with them. I was going to start with a question for Judge Breyer. Many court watchers assumed, following U.S. versus Booker, that would lead to an overhaul of the sentencing guidelines, something more than just amendments here and there, but a real revisiting of the structure. But as we've been talking about so far, that has not occurred. Instead, we've retained the same basic model, leaving the guidelines advisory. What has been the effect of Booker leaving an advisory? What should we do? What's wrong with doing that? Is there a problem that even needs to be addressed?
I think it's had a profound impact on sentencing and to the good. Let me make two comments before I go further. First of all, I thought that everything that my brother said to me was absolutely correct, but please don't tell him I said it. Break all precedent. And secondly, I was going to say that not about precedent. Oh, it's correct. I agree with him. The second thing is I was going to say to Judge Newton that he has nothing to atone for. Because in a sense, And I think in a good sense, the sentencing guidelines work pretty well. They are now, after Booker, placed there for its anchoring effect. Frequently, judges do not know where to start, and the sentencing guidelines give you that. Secondly, the fact that you can consider all the 35538 factors allow for individualized sentencing where necessary. I would say that there's a third test that you ought to consider. Our audience, that is what the guidelines are meant to address, are judges who have to apply them. We talk to judges. And the interesting thing, in a recent FJC survey, judges were asked, do you like the present guideline system? Do you not like the present guideline system? Which would you prefer? I think it's over 70%, maybe 77% of district court judges said that they like the system as it is. So I think there is some success in implementing this particular system. Now, in response to the question about Booker, I think it's extremely important that we talk about, or at least recognize, the separate function that the Sentencing Commission has in gathering statistical information. Because that will then inform judges. The point is, for sentencing purposes, we want to be evidence-based. We want to see what works and what doesn't. And the problem you get into is that every judge who comes along and everybody involved in the system will have their own sense of what a fair sentence is. What a light sentence is, nobody knows. What a fair sentence is, some people have ideas about them, judges try to implement them, but my idea about what is fair may be very different from some other judge's idea of what's being fair. So ideology can have a pernicious effect because judges try to do the right thing and they may end up doing something that is widely disparate depending on their own circumstances. The Sentencing Commission, in its evidence-gathering function, provides a national and regional picture of what judges do in terms of sentencing. And from that information, sentencing policy in terms of amendments and so forth is then enacted. I'd also say this, that I agree with Judge Newton. The sentencing guideline manual, you have to combine two qualities that would make you a great sentencing judge. Number one, you have to be a very good sentencing accountant to be able to figure out all of these things. And two, you ought to be an expert in the Talmud. Because if you are, you can work your way through this mandate. Unfortunately, we're not all that. And there is something to be said for simplification. I think that the point made earlier that Congress has made our task much bigger in terms of sentencing. Mandatory minimums and directives have an effect which is contrary to nationwide experience in any particular case. So you have to look at the evidence, and that's one thing the Commission does, and it makes it easier then to get to a sentence that is more uniform throughout the country.
That ties into what I was going to ask Judge Hinojosa. Paul Martin said this morning when you were describing the process of when we first started working on the commission, everybody hated us. And I wrote it down because some people might say not that much has changed. People criticize the guidelines, but how much of that criticism do you think is fair? And maybe it makes sense to comment on how much of it comes from the guidelines themselves and the work of the commission, and how much of that is Congress putting its fingerprints on it.
Well, I guess I'm one of the few judges left who actually did sentencing before the guidelines. And I did 4 years without the guidelines. I've been on the bench 34 years. I was 33 when I took a job. I didn't hate the guidelines. I thought they were a great idea, I have to say. I would spend a lot of time trying to avoid disparity within myself, within sentences. I work on the southwest border, so we have a very heavy criminal docket. It's not unusual for me in a year to sentence 800 to 900 people. In those days, of course, it was a lot less. We didn't have the southwest border immigration and drug trafficking cases that we have now as far as numbers. But I think that most judges do like the present system. In fact, in 2010, as Judge Breyer mentioned, there was a study made, and 78% of the judges strongly agreed or somewhat agreed with the fact that the guidelines have reduced unwarranted sentencing disparities. 16% somewhat disagreed or strongly disagreed, and there were 6% who were neutral. I don't know that judges are ever neutral, but apparently in that there were. Whether the guidelines that increase certainty and meeting purposes of sentencing, 76% of the judges agreed or somewhat strongly agreed or somewhat agreed, and 16%, the same 16% of the other question, I suspect, somewhat disagreed or disagreed. With regards to increased fairness in meeting the purposes of sentencing, 67% of the judges agreed and 24% disagreed. And so therefore, when you look at that, and it represented a return of about 69% of the federal district judges in the country, it's a pretty good indication that the judges do like a guideline system. And for those of us who served without a guideline system, there was terrible disparity, and it wasn't just regionally in the United States. Sometimes it was in the same courthouse. And the defendant and the defense attorney and the prosecutor knew there was going to be disparity the moment the judge was picked as to who it was. Sometimes it was just two of us in a courthouse, and it didn't matter in their viewpoint as to who was going to get the case. I'm not saying one or the other was right. I'm just saying there was disparity. There was a very serious lack of transparency. If anybody thinks that I didn't consider all those factors in that big manual with regards to a particular case as to what the appropriate sentence was, they're just wrong. Of course it mattered to me, as Chief Justice Breyer has pointed out, the amount of the drugs. Of course that mattered to me. The type of drug, of course that mattered to me. What level of role the person played, whether it was an increase in the role based on being a leader or a supervisor as opposed to someone who was minimally involved or somewhat involved but less than normal. All of those things I considered. Was there a firearm involved? Of course I considered that. And I didn't have to tell anybody. So the defense and the prosecution really couldn't address all the things that had gone through my head in trying to determine what the appropriate sentence was. So it really wasn't very transparent. Today, when I sentence somebody to start considering those factors, both sides get the opportunity to speak and go ahead and tell me why or why not what I'm thinking is correct. And I think that's a big difference in the fact that we have some transparency, the fact that the defendant and the prosecutor actually know what's going through the judge's head is one of the big things that the guidelines have added to sentencing. Are they complex? Well, maybe, but 80% of the cases are either drug, immigration, fraud, or firearm cases. So yes, the manual is big, but most of the time we only end up at certain portions of that manual. There are other portions that we really never have to touch because they're crimes that we rarely see. And so I don't find them very complicated at all. To me, the most important part is the fact that we have this discussion and we know that everybody, no matter what part of the country they are being charged in and tried in, are actually looking at the same factors to make those decisions. Pre-sentence reports are awfully important. We as judges should always keep in mind that is a report from the probation officer. We are the ones that still have to make the findings. The idea that somehow we no longer make findings as judges, whether it's relevant conduct or otherwise, of course we make those findings. That is ultimately our responsibility. Just because somebody mentions it doesn't mean that we're actually going to believe it. So we have a lot of discretion from the standpoint of fact-finding. And that's what was meant when the guidelines were created. And that's what we as judges need to keep in mind, that of course we have that ability to have discretion with regards to the fact-finding that goes on with each one of these cases. And so, are they complicated? Sentencing should never be simple. It is a very difficult thing to actually pass judgment. I have to say I had very, very little criminal experience when I became a judge, and I thought that was going to be the easiest part of my job. Somebody committed a crime, they need to be punished, how hard can that be? Actually, it's a very complicated part of our job, with or without guidelines, because every single pre-sentence report, every single individual, every single prosecution of each case is different. and with different fact-finding that has to go on, and different nuances. And if it ever becomes simple for us to sentence somebody, well, we're not doing a very good job in our criminal justice system. And so I think there is criticism, but we tend to hear a lot from the same voices. By and large, the judiciary, just like everything else, you tend to hear from the people that like to speak up on these subjects as opposed to the ones who just day in and day out do the job. And so therefore, it's hard to tell whether supporters or people who don't approve that system. And Justice Breyer brought up a very good point that I find easy to deal with, and that's departures versus variances. There isn't a departure that you want to do with regards to a case that is out of the ordinary that is not in that manual. The idea that you have to go to a variance when there is so much departure language in the manual itself, and frankly, when the statute was written, if you go look at the legislative history, they felt that 20% of the cases were going to be departures. And that's not too far from what it is now, based on within guidelines and departures based on government requests. And so therefore, we're not too far off from the legislative history in the original statute.
That's fascinating. So many times a day we have heard a call for simplification. And that seems to be the leading reform models all seem to recommend. One way to get around the remedial aspect of Booker and get us back on either a presumptive or even mandatory sentencing scheme is to simplify and apprentice, I guess, the guidelines. And I guess, Judge Saris, I was going to ask you to maybe comment further on that. Why the call? Why are the calls to simplify if they're not that burdensome?
So let me just start off by thanking Hofstra for having this symposium. You know, that one you had so many years ago when Justice Breyer spoke, generated an article which I then handed out at absolutely every baby judge school for new judges as to the clear decision points in the guidelines. So it's really appropriate 30 years later that you're doing it again, and thank you. And I'm also very proud of the Sentencing Commission team that put together this early history, Brent and David, who are sitting here, and the whole, and really a lot of members of the team. You know, 50 years ago, the Johnson Commission called out for a commission that would have the expertise to create evidence-based guidelines, the statisticians, historians, people who actually studied it, and in fact, the Sentencing Commission today is providing that very expertise that has long been called out for. Before we judge whether or not a sentencing commission guidelines are fair or not fair, I think simplicity is only one of the many measures that you would have about thinking about a guideline system. And I just want to go through. The first is fair and proportional. You want a fair sentencing commission guidelines that are proportionate to what the person actually did. And the second I would say is there unwarranted disparity? That was when I was working for Justice Breyer. That was what you heard in Congress. Are these guys? Why should a bank robber in one place get a lot more than a bank robber in another place? Simplicity, whether it's too complicated means it's not transparent. You're Talmudic, you can't understand it. And last, I think, luckily for all of us, the word rehabilitation has come back into the way we're talking about sentencing. But going back, and they're very related concepts, because if it gets too high, so the judges don't feel it's proportionate, they start to vary. If it's too simple, like a mandatory minimum, the judges think are too high. That's simple, there's no disparity, but people don't feel good about the system. So, as Justice Breyer said, there's no perfect sentencing system. It's a trade-off of values between all these different goals that you might have. I do think, though, that it is too complicated right now. I think when I was speaking for myself right now, but I think it would be fair to say that there's hardly anyone who would disagree with that. And one of the key issues that's been mentioned again and again is so many enhancements. When you first started, I loved Brent and David's work when they said that the early Sentencing Commission only looked at those enhancements which were significant, non-trivial, just a few of them the judges thought were relevant. Now we have, I think we joked, Kathleen and I, there's a Christmas tree of enhancements with 19 on the broad guidelines. It keeps going up and up and up, and it's not just in tiny increments, it's in huge increments, because you have this logarithmic table that, so if you're at one end of the table, it's 5 years, not a year. And so it's, I think one way that we could simplify within our current structure would be to eliminate the enhancements from the add-ons, as we refer to, just eliminate a lot of them and make them in a post-Booker world variance considerations. I think you could probably pretty easily do that and yet reflect what Congress or the individual commissioners at the time, you could just put them into the commentary so judges could think about it. I think that you could get rid of all the cross-references, which are almost never followed anyway, and are very hard to follow. They take you from one guideline to a harder guideline. And I also think that the hardest nut, which we really didn't talk too much about, is relevant conduct. I think when I was a state judge, I used to sentence under the indeterminate. You took into account how many drug deals someone did. You did, even if it wasn't the actual charged offense. But what's hard for judges, and I think for defendants and for the system, is when you're taking into account the conduct of other people in a conspiracy or uncharged. So I think you could narrow all of this within the current system. You could simplify it. You could make it more proportionate. And I think that in general, you could have a work based on the evidence that we have at the commission and making it a fairer system. So I think it's very relevant to offensive conviction.
Judge Stitt, or Professor Stitt, I'm sorry, I wanted to make sure to give you an opportunity to comment on the themes we've been discussing first, but also wanted to talk to you about the division of power between the sentencing judge and the prosecutor.
Yeah, well, the authors of the Sentencing Reform Act realized that if you're going to take away judicial discretion, there's a real danger that you're going to just transfer it to prosecutors. And they work to avoid that. The Sentencing Committee, there was a lot of commentary on this, and the Senate, which was really where this was developed, deliberately did not require a charge offense system, because if it's a charge offense system, then the prosecutor gets the charge, right? And Stephen Breyer has explained how they have this modified real offense system. The idea there was, if you're going to be sentenced on a real offense, and it doesn't matter what the prosecutor says, the probation officer is going to report to the judge with real offenses. But something else happened. And despite all the paper in the corner, you had the wrong algorithm. Because if you look at sentences before the guidelines and sentences after the guidelines, and I publish papers on this, just postal fraud, postal theft, take any crime, they went up tremendously in the first guidelines manual. And I think I could tell you statistically why I think that happened. This is not intended, except in a few areas where Congress told you to increase sentences. The result was that you had guideline sentences that prosecutors thought were too high. And judges didn't play much of a role, so they thought they were too high. So there's room for fact bargaining. And this began within a couple of years of the guidelines coming down. The prosecutor and the defense attorney would fact bargain. So we're going to leave out the vulnerable victim edition. We're going to leave out the obstruction of justice. It's not enough to actually charge it under statute. This has a very broad definition of obstruction of justice, which, by the way, wasn't in pre-sentence reports. Certainly not all 10,000 of them. Was that checked off or not checked off? So there's a lot of things that made the sentence high that you could just not talk about. Tony Garoppolo, the head chief probation officer of the Eastern District of New York, called fact bargaining the dirty little secret of the guidelines. He said that in 1992. This gives a big incentive to plead guilty. You're not going to get your fact bargain unless you plead guilty. So I don't think there was a direct transference to the prosecutors, but I think that was a problem because the guidelines started out too high. Then two other things were much more important. It's really not even the guidelines' fault. One, we have the mandatory minimums, which are ridiculously high, doubling sentence of the lady who's cooking crack. She's getting paid maybe $6 an hour by the dealers. And if you happen to charge this as a 1 kilogram crack operation, you're going to get a very different sentence than if you charge it as a 20 gram operation. And that might be all that's in the room at the time. But, if the agent stays on the case or has other proof, suddenly everybody, because that relevant conduct counts for her too. And so she's going to get a higher sentence, and with the mandatory minimums, she's going to get a very high sentence, particularly if she has any past felony drug conviction in any court in the world. Under 851, her minimums and maximums, her minimums are going to be doubled. We had that happen, and then perhaps the biggest mistake of all, which nobody's mentioned. As we said, everybody's concerned about disparity. Everybody's concerned about giving prosecutors too much power, now that we're taking most of it from judges. So, the Department of Justice says, gee, we don't want prosecutors to be introducing disparity into the system. So, for the first time ever, we're going to have a policy on charging and plea bargaining that we're going to write down in the Department of Justice and we're going to send out to everybody. It was Attorney General Thornburg, 1989, and he said, well, what should be our policy on charging? If you write down policy on charging, you can only write down one thing. Charge the most serious, readily provable offense. Now, I was a prosecutor early in the 1980s. We didn't have any such rule. Well, the rule we had was the requirements of the principles of federal prosecution, the preamble to Title IX of the U.S. Attorney's Manual, that said, charge only what you think you have or will have proof beyond a reasonable doubt of, and charge what is just and appropriate. It's very different from the most serious, readily provable offense, especially when a few years later, in 1993, under Janet Reno, in fact, the Department of Justice made clear the most serious, readily provable offense includes mandatory minimums. You've got to always charge the mandatory minimum. You've got to always charge the 851 sentencing enhancement for a prior felony conviction. These decisions, so the guidelines which inadvertently were more severe than intended, the mandatory minimums in certain areas, and in every area, this new Department of Justice charging policy resulted, I think, in such severe federal sentences, the exponential increase in the federal prison population, and extraordinary prosecutorial ability to use these mandatories, etc., as 2x4s to induce guilty pleas by those prosecutors who were so inclined. I guess I'll end with my final concern is that when I was a baby prosecutor, we were not told, be as severe as you possibly can be so the guy can plead guilty. We were told that's not our role. I worry that the culture has changed, that the medium of exchange has changed. What I thought was a serious sentence for a white-collar offender would be 3 years. Now, unless it's double digits, you really have to punish the guy. I think this goes beyond the Sentencing Commission to larger questions that the Sentencing Commission is but one institution trying to deal with, and I commend it.
Yeah, I want to say a little bit about prosecutorial discretion. Frankly, that's the way our system is built. It starts with, let's say you're speeding, you get stopped by a Department of Public Safety person in the state of Texas. The discretion is going to be with that person as to whether they're going to give you a warning, whether they're going to give you a ticket, whether they're going to charge you with that or not. And so I don't know how we could change our system from the prosecutorial discretion, whether it starts with law enforcement officials or goes all the way to prosecutors themselves. That's just the way our system is built. You'd have to have some complete change with regards to our system of prosecution. And then, that depends on who the Attorney General might be, and things change with elections and everything else. And unfortunately, that's the way the system is. And so there's nothing the Commission can do with regards to changing the decisions of what prosecutors do and don't do. I failed to mention that one of the things that really, and it has been mentioned before, is I used to do a lot of guessing without the guidelines as to how much time somebody was going to spend in prison. And I knew what I thought was right. And so a lot of times, if it was a 20-year maximum, I knew that there might be a third and not more than 2/3. So I would kind of figure out, well, how long does this sentence has to be? And that's been mentioned, and we did it all the time. There was no transparency with regards to that, but that's what we did. Guilty pleas, they've gone up a little bit because I think to some extent defense attorneys are able to visit with their clients and explain to them, if you get convicted, this is likely what's going to happen. Some people say, well, you're threatening somebody to plead guilty because you give them credit for acceptance of responsibility. My answer to that is that really is part of our culture. As a child, I would go to my parents, if I tell you I did something wrong and admitted it to you, would punish me less. And it seemed to work. And so I do think there is some credit to be given for acceptance of responsibility. The amount of time, the truth in sentencing, I think was a very good idea. And yes, there is a 15% deduction for good behavior if you get more than 12 months. Sometimes you sentence somebody for 12 months in one day, and they look at you like, why are you throwing that one day at me? And you have to explain it's because you can get up to 15% of the time off if it's more than 12 months. And the good time is really basically appreciated very much by the people who work in the prison system, because they say, well, this makes it easier for us to have some control with regards to good behavior within the prison system. At one time when I was chair of the commission, we had some Russians come visit, and I was trying to explain good time behavior. There was a question immediately, why do you all have any trouble taking care of the way people behave in the prison system? Well, I suspect their system is a little bit different as to how they keep control within the prison system. But that's one of the reasons for this. And the penalties did get higher to some extent, and mostly in white-collar crimes, because I think Congress felt that we as judges were identifying more with white-collar criminals because they tend to have the same kind of background that we do. They have good jobs, good education, family structure, all those things, and I think maybe the penalties did get driven up in the white-collar criminals, and I suspect that was probably because we tended to identify more with them as judges because we felt they had this kind of the same background, and this was going to be very hard on them and all these kind of things. And so, yes, penalties did rise, but I think that's one of the reasons they did.
I want to talk for 1 second about mandatory minimums. The Sentencing Commission in, say, 2011 came out with a report. We were all over the place on whether we agreed with mandatory minimums. Some did, some didn't. I didn't believe in them, but others did. But what we all did agree on was that they were too high and swept too broad. That's what we all agreed on. And things do change. You know, there is, what's the word, it's evolutionary. People's views have changed on this. So that in the last Congress, I mean, one of my big disappointments when I finished is that we didn't actually pass this legislation, which had bipartisan support, both sides, you know, people agreeing that to lower the mandatory minimums. And I think to some extent that the prosecutors always have that hammer. So to the extent they have that hammer on what to charge and when to charge it, if there's going to be some really unfair sentencing going on, whether it's the 851 enhancements, the double, or the stacking that brings it up to life, it's really a far bigger problem, in my view, in the system right now than guideline issues. And of course, the guidelines are made to be consistent with them. So I think we missed an opportunity in the last Congress, but I don't like to say never. I mean, the Sentencing Commission lowered drug penalties by an average 2 years. It affected over 40,000 people eligible for lower sentences. I think there is an urge to try and make sentencing more fair and proportionate. But most importantly, I think Congress has paid attention, and that's, as Justice Breyer said, they're the ones who write the laws. And well, I'm not as hopeful in the sense that I think right now there are other things higher on the table and priorities that maybe for the Congress. We came so close last time, so close, that I am hopeful that is going to be part of a national discussion again.
And let me respond to Professor Smith's observations too. One, our sentences are too severe, and secondly, that prosecutors have too much discretion in their hand. I don't think, as to the second point, there's really anything that the Sentencing Commission can do about it. Traditionally, as Judge Hinojosa points out, this is the way the system is created. You try to take these things into account, but I'm not sure that the Commission can do anything about it. As to the first point on the severity of sentences, interestingly enough, the commission can do something about it, and has done something about it. And I think that while Judge Saris sort of just mentioned it, about the reduction on drugs -2, it was a monumental change. And the reason it was successful, in my view, and was bipartisan or nonpartisan, was because the commission took a look at the evidence. Now, what did the evidence show? We had a prior example of where there was a retroactive application of the reduction between the difference between powder and crack cocaine. And what it ultimately came to was that there would be this reduction, but it would be up to individual judges to determine whether or not they wanted to readjust the sentence of a defendant. Now, you might think, well, that's terrible. There were disparities and so forth and so on. You might be right, but we found the silver lining. What was the silver lining? The silver lining was that we now had two groups to follow. Those people whose sentences were reduced and those people whose sentences were not reduced. And we could follow them for 5 years, which is what the Sentencing Commission did. What was the conclusion? The Sentencing Commission found that there was really, from a statistical point of view, no disparity between recidivism rates for those people who got a shorter sentence than those people who got a longer sentence. What did that tell us? It told us that it's not necessarily the longer sentence that is the safer sentence, that is safer for the community. It told us that. And we were able to publish that. And we were able to tell 846 judges and so whatever it was, look at these statistics. Look at them from a national point of view. That may inform your judgment as to whether or not the longer sentence should be applied. So I'm a great believer in gathering the statistics. I think statistics will be whatever you want them to be, but it's important to try to have some evidence-based sentencing system, because if you don't, you're going to have individuals, good intentioned individuals, doing what they want to do. It also tells us two other things, something else in terms of sentencing. We have seen, maybe three things, we have seen in certain areas a high degree of compliance with the sentencing guidelines by judges and a low level of compliance by sentencing judges. It has, and within a particular range, it has told us a lot. Fraud, as an example. We have seen judges basically, in large numbers, follow the sentencing guideline range where there are shorter sentences. It's the outlier, it's the high loss figure where you see the disparity between the sentencing guidelines and what judges do. Now the question is, should that be fixed? And that's really a function of a lot of things, including what number of cases you're talking about. You're talking about thousands of cases, you're talking about 100 cases, or 50 cases, because that's an important consideration. Secondly, on child pornography, I know that's a very hot issue, but it's a political issue in large part. And the judges, in large part, in cooperation or along with prosecutors who see it on a daily basis, try to come to some conclusion as to what is a fair sentence in any given situation. And we see it statistically, and we report on it statistically. You can look at the sentencing guidelines in child pornography and say, why do you enhance a sentence for the use of a computer? It's a directive by Congress. Anybody who has pornography cases knows that a computer now is the heartland. Almost every defendant uses a computer. So why is it an add-on? Well, it's an add-on because Congress told us to make it an add-on. So I'm a believer that Congress should lead sentencing, basically, these sorts of characteristics and so forth, to the Commission, which will base their opinion on the evidence. What does the evidence show? And I think that is an important factor, and that may go to Professor Siss' first point, because it ultimately may make the Commission look at what are the statistics, what is the truth of the matter in terms of sentencing, and then you form some opinion as to whether or not a sentence is too severe or not severe.
If I could respond to a couple of points. First of all, just to go back to Booker for a moment, Justice Breyer said, I told them, now he's talking 20 years ago, I told them in 1999 that follow the guidelines, and if something's out of whack, then depart. But unfortunately, that's not really what the guidelines said. The guidelines require the judges follow their rules not only with respect to calculation of the guidelines, offense level and all that, but also their rules with respect to departure, which for a long time were very rigid and narrow. But it is sort of the system we have now, thanks to Justice Breyer's remedial opinion in Booker. And, you know, the surveys by the FJC before Booker, really, from the time the guidelines were issued up until the last survey in 2001, the great majority of district judges did not like the guidelines. Now they do like the system, and it's the post-Booker system which allows judges to depart or vary or whatever they want to call it. Secondly, you know, I disagree with somewhat Judge Breyer that we don't really have to worry about this problem of the fraud guideline top numbers putting people in jail for decades and decades because there's so few cases. If you happen to be an accountant at a public company and you participated in a securities fraud and you just got paid your regular salary and you may not have known how fraudulent it was, and any of it, you're doing your job, the guideline sentence is ridiculously high. And in about half those cases, judges now in the post-Booker regime do depart significantly. It's not just they depart significantly. I'm worried about the judges who are imposing the guideline sentence. Even if it's only 87 defendants a year who are unnecessarily having their lives taken away from them. One other thing, although I'm very grateful for what the Commission has done in recent years, but I think you could do more. This drug table, having the quantity of drugs tied to the mandatory minimums, means this. Okay. In fiscal year 2016, of all the defendants who were convicted of a crime carrying a mandatory minimum, nearly 40% of them received relief from that penalty, either because they provided substantial assistance and the prosecutor filed a motion, or because of the safety valve, or in 5% of cases because of both. Yet those defendants' guidelines sentences were just as high as the mandatory minimum because the guideline sentence is pegged to the mandatory minimum. And even if you're a little bit below the quantity level that triggers a new mandatory, your sentence is going to be up close to that level. And there's a way to solve this problem, and that is to not have the drug table be an extrapolation from the cliffs of Congress's unfortunate decision to have mandatory minimums, and here's such high mandatory minimums. I know reformers have been making this argument for years. I just didn't want a day to go by without
It sounds like we're getting a fascinating enterprise for somebody to speculate what purely evidence-based guidelines would look like if you backed out all of the mandatory minimums and the add-ons. Judge Sarah, do you want to say something in closing? Look, I've been told we're running out of time.
Well, but just very quickly, I'm going to go back to this notion of the commission and whether we're evolutionary or not. I was lucky to be there at a time where we looked at all the major crime groups, shall we say, and had current evidence about what was going on and what judges were doing. And it wasn't just in reducing drug penalties based on the evidence about what judges were doing, but we also looked at the career offender guidelines and with a very insightful, I think, report on how the statute needed to be changed based on current evidence of who was dangerous and who wasn't dangerous. In the immigration context, we looked at what judges were doing when it was too high and recalibrating it. And I don't want to go through all the granular details of each one of it, but I just want to assure folks that it's not as wonderful as the original history was, but we haven't been stuck there, and we have been following the data, primarily what judges are doing, and also what criminal justice scholars are doing, say in juvenile crimes. We've been following that science, and really both recommending to Congress changes and doing it ourselves. So that's, I know everyone should have a chance, so I'll just stop there. It was a privilege to be chair.
Anything else? Thank you so much.
I can say something.
From my point of view, I haven't thought about this in a long time. I think it's fabulous that you're having this conference. And what it called to mind, you're having, because just the interest in the intellectual work and the thought is very, very helpful. And I thought what Kennedy said, which is true, when we started this out, he said, well, one virtue of moving to the guideline system, aside from others, in a very general aspect, is it will get people thinking less about, did he do this thing? And because most people did. But more in the direction, I'm saying you shouldn't think of that, you should, okay. But more in the direction of what do we do with this human being? And the very fact that you're having this conference suggests that that part, at least, has been working up to a point. And if there are other things, listening to the problem at that general level, I think, you know, there are other countries, if they want to turn power over to the prosecutor actually to do the sentencing, actually to do the prosecution, they do it. But they have schools to train them. And they say, if you are going to be a judge, we'll train you to be a judge. And that's true in France. It's true in Spain. I don't know about Canada. But I'm at a university. And so I cannot help but think of that very general direction. I know it's pie in the sky, but why not? And the third thing it makes me think of is an article I read the other day, which said that there are 66% of the American population employed in the year 2000, and today they're 62%. And the person who writes about that difference of 4%, which is about 12 million people, says that quite a few of those millions are people who not only are serving in prison, but who have served in prison. And it's very hard to find out what's happened to them. Very hard. And he connects it with a decline in mortality rates and the use of drugs and a lot of other unfortunate things. So I would say if we're expanding our highly general abstract notion in the direction of prosecution, let's train them as judges, perhaps. And let's start thinking about at our universities and other places, what can we do as well with the people not only who may go to, who are in prison, but also what happens when they leave. You have produced all those thoughts. I hope some of them will catch like fire among you. Thank you.